Thanks, everybody. Hi, welcome to everyone. We have everyone entering the meeting now, so we will just be waiting a few minutes and then we'll get started with the presentation. Thanks for making time for us today, and we look forward to presenting to you. All right. Hi, everyone. Our numbers are still climbing a little bit, so we're just going to wait another minute or so. Thank you to all of you for attending. We're excited to be talking to you tonight about all things legal in condominiums and what that landscape looks like. So thank you again for attending, and we're just going to give it another couple of minutes. Okay, I think we have slowed down a little bit on everyone attending, so we will get started. Thank you, everyone, for attending our board education series. Tonight, our title was Let Me Run That by Legal. Always a fan favorite out there, the legal session, and this is how we'll close out 2024. First, I'd like to introduce you to our panel. So I'm Casey Beacock of Sanderson Management. I will be your moderator this evening. With me is Caitlin Beacock. She does the tech side. So thank you very much. Also, we have Evan Holt of Shibley Righton. Evan works with clients to find effective and practical solutions to a variety of condominium-related issues. Evan's practice includes assisting clients with the enforcement of condominium document provisions, the drafting of shared facilities agreements, and providing opinions and assistance with respect to general condominium governance matters. He has also represented clients at the CAT and civil litigation matters, and has experience assisting land developers acquire land, register condominium plans, and complete condominium unit sales. Thanks for joining us, Evan. We also have Natalia. Natalia Polis is a senior lawyer at Lash Condominium LLP. Her practice focuses primarily on condominium litigation and assisting in governance issues. Natalia frequently represents clients before the Condominium Authority Tribunal, or the CAT. Thank you so much for being here tonight, Natalia. Much appreciated. And last but certainly not least, we have Rob Mullin of SV Law. Rob is a knowledgeable leader in Ontario condominium law, writing and speaking frequently on the subject. Rob routinely advises condominium corporations on the creation of standard unit bylaws and indemnity agreements, the adoption of the declaration bylaw, rule amendments, enforcement procedures, including liens and powers of sale, mediation and arbitration, and compliance orders. Rob is currently authoring a textbook entitled Condominium Law, expected in 2024. And Rob is also an instructor at Conestoga College, teaching condominium law to future property managers. Thank you, Rob, for being here tonight. Awesome. So one thing we like to do for our sessions is I do ask a question of our panelists ahead of time. And then at the end, I let you know who was who. So tonight's question was, if you could be a cartoon character, if you could hang out with any cartoon character, who would it be and why? And so we have three answers. And at the end, I'll let you know who was who. So the first one is that this panelist would hang out with Spider-Man. Because he thinks that Spider-Man is able to move around quickly and deflect and put up with bullying, and he had to choose an answer. So that's why he chose Spider-Man. Oh, and the next one would hang out with Winnie the Pooh. And the reason for choosing Winnie the Pooh is that Winnie the Pooh knows where to find the best honey. And last, and certainly not least, this person would like to hang out with the Pink Panther because I've always wanted to be a detective and I love true crime. I'd live out my childhood career dreams for a day. I think that is a fantastic one. I know we have a lot of true crime enthusiasts on this call, so good choice. All right, let's get started. Here we go. Tonight, we wanted to talk about all things legal and how we run to legal. And we'd like to talk to the boards about what the current trends in the condominium landscape look like and how that affects boards and budgets and all things moving forward. And so I guess at this point, we're going to start with the question of, Evan, what do you think the role of the manager is in legal situations?
Yeah, so management's role is, of course, once they discover a situation that they feel may need legal involvement, is to bring it to the board. Possibly even consulting with legal initially just to get some general indication, because of course the board's going to have questions for management as soon as it's brought to the board. But once it's brought to the board and the board has an opportunity to digest it and discuss it, it's really for the board to provide instructions to management, for management to perform those instructions, which generally may include going to a lawyer, getting an opinion from a lawyer, finding out where the lawyer is recommending next steps lead, and what sorts of actions the corporation can take. And the manager really serves as that liaison between the board and the lawyer. Lawyers don't want to get inundated with 30 emails of the board making decisions or debating things like that. And so we like to see the board have those discussions, of course. Those are informed by management, and management kind of moves the decision to legal, for legal to act on there. Of course, legal's happy to join boards and discuss particular items if they need direct contact with it, but we try to stay out of a lot of those decision-making experiences.
That totally makes sense. Natalia, at what point should a board reach out to legal? Where in the process? When does that make sense?
So also just to build up on what Evan just mentioned, a lot of times what I've seen is a reoccurring trend is that oftentimes boards don't want to get legal involved, obviously because of the expenses and the legal fees that accumulate when legal does get involved. So the initial advice comes from the manager based on the manager's experience. And sometimes that's not necessarily the exact legal correct or way a legal representative would advise the board on how they should proceed on, let's say it's an enforcement matter or whatever the issue may be. And oftentimes getting legal involved earlier in the process could actually reduce the legal fees in the long run, because legal could then provide the recommended approach, how to proceed, let's say in a noise-related dispute, which for an example, I have one going on right now where we just got involved and we're deep in the CAT proceeding. There's never been any investigations. There's never been anything done about this noise-related dispute. However, had we got involved maybe a few months ago, from the initial outset of these noise complaints being received by the Condo Corp, we could have been able to resolve this much sooner. But now, unfortunately, we're in front of the CAT. We have to defend this and we have to try to put our best foot forward to hopefully get the resolution that the board ultimately wants. So oftentimes getting legal involved earlier and getting that opinion off the offset of any dispute could avoid protracted legal fees, litigation, etc. in the long run. I know it's not the answer that a lot of board members want to hear, since it does involve incurring those legal expenses sort of from the beginning. But again, the beginning, maybe just that small amount of legal fees rather than protracted legal fees in the long term.
No, excellent points for sure. And Rob, how do we, as managers and boards working together, how do we make sure that we can bring legal in when we want? Because we all know that legal is typically an expense line that doesn't have a lot of money sitting on it. It's not something planned to spend, right? So
absolutely. I think the most important thing, just to build on what Evan and Natalia had to say, property managers aren't lawyers, simply put. And the idea of sending a property manager to do a CAT case is a little like sending your surgeon to do the reserve fund study, any more than me doing the audit. So we've kind of lost our way, I think, a bit in the industry. It doesn't mean that lawyers are short of work. It means that we are perhaps trying to save fees and save on incurring legal costs, and then sending a manager to do a CAT hearing when they have had no professional training in that space at all. And CAT hearings, despite what the CAT has said, and it's kind of, I know this is being recorded, but the CAT has got some rather self-serving language on its website where it's citizen friendly and user oriented and all these wonderful kind of signals that it's easy to use, and then they reduce their decisions to 30 single space pages of intense legal analysis in the space that Natalia is in every day. And how could someone who isn't professionally trained in this space do it? So core message: managers shouldn't be lawyers any more than managers should be auditors. But the reality of it is probably some of the hesitation is because what happens is that a legal issue comes up and someone looks at the budget, and the budget for the legal for 2024 is, wait for it, $0 or $500. Fantastic. Excellent. So legal is often lowballed in an annual budget for a condo. I appreciate why. And if you spend $1,000 and the variance is therefore 100%, the landscape budget could be $50,000, but it's that legal bill that's going to get the question mark from the unit owner at the AGM. How come legal doubled in its spend? I think we have to start getting cultivated in the fact that condos they are a legal entity and they do need legal services, enforcement, opinions, litigation, liens, you name it. They are an ongoing entity that needs legal assistance. So I think we have to be intentional to say that condominium corporation does need legal service on a basis, and it shouldn't be a crisis every year if you need a lawyer and then we don't have the budget. So I think you look at what you spent last year, it's probably a good indication what you may spend next year, and probably budget for that.
I think those are great points for sure. And what duties do the board have when they're in a legal situation? So what duties, there are certain tasks that boards should do if they're presented with a conflict or a situation that may require some legal help. Who would like to answer that?
I'll jump up again. I guess it's on my rotation here. Yeah, there are. The board needs to, and the corporation, and I'll say the corporation needs to, because it's not always just the board. When you're dealing with noise complaints, odor complaints, and things like that, the duty to investigate and to take reasonable measures to resolve complaints and things like that. It may not be sufficient for just a board member alone or board and management working together alone to resolve. You may need to get other experts, which goes to that earlier discussion we just had about what's your legal line item, what's your other expert line item, because you may need the assistance of an engineer to figure out, hey, where is this smoke coming from and how is it entering this other unit? You may need an engineer to determine, is the noise being experienced in a particular unit above what we would see as a reasonable threshold. You don't always need that level of expertise, but there's certainly instances where it's really beneficial to have that level of expertise. And so, I think part of the board's responsibility is, of course, to investigate, but it's finding out what level of investigation is necessary. And that determination is going to come from a conversation with management, with your lawyers, finding out what we are going to need to succeed, and not just to succeed in final CAT matters or some sort of proceedings, but can we provide a unit owner that's complaining with qualitative data to show them that we appreciate that you may be experiencing this, but when we look at the data, it's not showing what you're complaining about. And so, we can't maybe take the steps that you believe are necessary here. So investigation can play both a role in supporting your case if you get to that kind of adversarial approach, but it can also really help in trying to find a solution before that as well.
And just to maybe hop on to what Evan was saying, and this is what I see oftentimes happening in corporations where, let's say, management's only there part-time, and of course they're gone after work hours, and there's no superintendent, there's no concierge staff. and you have unit owners or residents complaining about noise at 11 p.m. or 9 p.m., but you don't have any third party on site to actually investigate. And so it becomes difficult to actually provide that third party verification needed to either take the enforcement steps or alternatively discredit the person complaining. So sometimes those board members do have to take that step in and be that contact person to actually go in and provide that third party verification, which a lot of times board members don't want to get personally involved and go into units and do that sort of investigative work. But sometimes, unfortunately, in situations where there is nobody else on site that can do that, it is something that the board needs to then consider volunteering to do.
Absolutely. I think for me, the number one thing, I've read this, I don't know where I read this recently, but I read that in an organization, the quality of the question determines the success of the outcome. Meaning assumptions are that's what we should always be working against. I see a lot of boards, me included, we're all following this trap, but boards as well can fall into these assumption traps. Well, we know that individual, that person we don't like, or they have a bad history in the condo, so therefore we default to a decision quickly without asking the right questions. We've got all of us included, me included, we have to park our egos at the door. We have to go through the process. We have to look at through the lens of the community, not as their neighbor per se, not as a unit owner. You have to look at this through the prism of being a board member. You're looking at the whole picture and ask those questions. Now, if those questions come back and confirm your assumption, fine. And you've gone through a process and might have been a bit redundant, that's okay too. But if you're asking the questions and other people hear the answers, you've also informed them as well. So everyone's winning in that circle of conversation. So always attack the assumptions. Figure out if you actually know the story right to its core principles. And once you know the story solidly, then you proceed. A lot of condos, they knee jerk. And we're all the same. I'm the same as well. I'm not trying to pick on boards tonight, but we have to make sure the quality of our questions are sound and we actually ask them.
And I don't think we're picking on boards. I think managers can get that same message 100%, right? Because we're the same way. If we're getting, bombarded from one unit owner and then suddenly they make a complaint, do we have a perceived notion of what the answer is? Of course we do, right? So, because we're all human beings, that it's what we do. And it takes some critical thinking from everyone involved for the best of the community. And that can get tough because on the other side of that is not always someone who's critically thinking, right? Which makes it, it multiplies the emotion that's involved in it, right? I think when we were talking about this session, you guys made some great points about how do boards navigate this conflict in their community? They have to stretch their thinking and they have to put personal issues aside and put on their board hat versus their neighbor hat, right? So I think we can talk more, maybe some tips on how they can do that. And Natalia, I think that sometimes a board has to be that third party involvement. I think that's so true, particularly in our region, because we don't have a lot of the huge buildings that have that 24-hour in building or in complex person that can look at that, right? But what happens for that board member? Because we all know that board members are volunteers and the person lodging the complaint is already heightened typically, right? And is adversarial with the board potentially. So how do we navigate? Like, what's the other side of that? Like, maybe it's the board member who is in the middle, who's Switzerland. I don't know. I'm looking to you guys for some extra tips on that one. So,
well, oftentimes these situations where there is no other third party on site that could do this verification, I always recommend that at least 2 board members go to do these investigations, volunteer, whether on sort of a rotating basis, but as long as there's 2 people there, so the he said, she said, you'll always have that third party there witnessing what's actually happening, right? So you don't have that exposure to liability of only having the one director go and do the investigations, and then this adversarial unit owner or resident then makes certain allegations against this one director that's, again, a volunteering their time in the middle of the night to investigate the noise or the smoke or whatever it may be. Have that second person with you as a support system, and to make sure that if there are any allegations made against that particular board member going into a unit or whatever, especially as you mentioned, typically these aren't nice situations that we're going into. It's situations where emotions are heightened, frustrations are heightened. So having that second person with you is always beneficial in these cases, and doing it potentially on a rotating sort of scale. So it's not that 1 and 2 board members are always the 2 that have to do these investigations, but switch roles. So it's not you waking up in the middle of the night to have to do these investigations. On the flip side, we talked about finances and how to finance and budget for these sorts of things. I've had situations where board members don't want to get involved whatsoever. They don't want to be the volunteers that do these investigations, go into the unit, see if they smell smoke, and they then retain a security guard to on a temporary basis to see if any of these complaints are actually verified. But again, that's a cost benefit analysis. The volunteers doing it, being the board members, or then spending the corporation's money on a third party to actually be that third party to verify it.
And then we did get a question in the Q&A that asked, does the manager have a role in this process? Rob, do you want to take that one?
Can I jump on it? Yeah, the adage that, and I'm certainly not trying to paddle a different way, but you know, the thinking that I often have in my mind when I'm thinking of these things through is the adage: directors direct, managers manage. Directors direct. They are not, like, if there's an emergency, of course, Natalia is right. If there's something, there's no one else there, we can switch, great. But a lot of directors think that with their election, they are anointed as the sheriff of their town, and they walk around their neighborhood with the metaphorical 6-shooter on their hip, and they're kind of, you know, climbing on issues that maybe they perceive as a violation. The manager manages. That's the manager's job. The directors direct, the managers manage. So what's the role of the manager in this equation? Managing. They're the implementer. They're the doer. They're on the ground. They're the boots walk in the neighborhood. Directors deliberate. They meet once monthly. They should not be making decisions in the elevator. They should not be making decisions in the parking lot. They should not be making decisions, wait for it, over email or text messaging, which is getting to be a bit of a habit that we're all getting a little addicted to. Directors make decisions at director board meetings with all the facts and evidence in front of them. And if not, they're asking the questions and they get more. So what's the role of managers in this? Managing. Directors direct. They're deliberative. Managers are the doers.
Absolutely.
I completely agree with what Rob says, but the problem is the manager's not there at 2 in the morning when this is happening. In the situations where you don't have security, you don't have a concierge, you don't have a super, who's the person going to verify that noise? It's probably going to be one of the volunteer board members, because you're not going to call your manager at 2 a.m. and say, hey, can you drive half an hour to our condo and check out this noise complaint we just received?
Well, I will tell you that any
emergency situations, of course,
at 2 a.m. that comes into our answering service that asks to investigate a noise complaint will be held till the morning.
Yeah.
Just, you won't get any of my team out there at 2 a.m. I completely agree with you, Natalia. And that's where I think if we're having those nice complaints, this is where maybe it's part of legal, maybe it's part of other professionals, something where you have that security guard who can maybe go out because, you know, this unit's making noise every Thursday night, or, you know, it's been 3 nights in a row. Because we are able to make that happen. We're able to do that and manage that for sure. So Evan, you want to get in on this one?
Yeah, there may be also some more passive things as well. You know, again, on that line item of other professionals, you know, especially for noise and things like that, it's going to depend on the circumstances. You know, what's the frequency? If this is something that's occurring every night at 11 o'clock, you know, of course, having a security guard show up at 11 o'clock every day is going to probably assist with identifying the noise, assuming it continues after the first security guard's visit. But, you know, there are options which may be more costly. I'm not sure what the cost of a security guard is going to be to come on kind of an immediate basis, even on a temporary basis. But, you know, installing monitors to listen and detect the noise and actually get reports about the values of those noise. Similarly, you know, you can have these passive monitors for smoke. There are disadvantages to that. You know, we've got potentially tipping off the offending resident that we're monitoring them now because we're installing something, and do they become aware and change their behavior, and all of this monitoring equipment is for naught. But there may be other options there. But yeah, I think, you know, I think the question started off with, you know, what's the creative solution, or how can boards be creative? And I think it goes back to Rob's original point there of, taking off your personal neighbor hat at the start of this, really, when the complaint comes in, treating it with compassion, not just, oh, that's Joe at 402, he's just sensitive to noise down there. And really questioning your assumptions and trying to approach every conflict with fresh eyes and put a full reasoned investigation forward.
Yeah, and if I could just jump Evan's comments, and yeah, I certainly agree, directors, emergency, get out there. My comments are more directed, like the directors see the contractor out there and they don't think they're cutting the lawn fully, and the directors out there engage in the contractor, like that is so offside, we should write that in legislation that's legal. But just to build on Evan's point, if I could pass one piece of law in the Condo Act, magic wand, we get it overnight, security cameras in condominium settings monitoring the common elements, I would have that implemented tomorrow. The files that Natalia and Evan and I work on, where we actually have camera, either still photographs or actual movie, video of the guy backing into his garage door and crushing it, or running over the fire hydrant, or knocking over the light standard, all that without capture on camera changes the whole dynamic of our enforcement duties. It takes away the debate, the dispute, and it really, I think, expedites the issue. And with the precipitous diminution, a lot, this material 20 years ago, 30 years ago would have been, these massive cameras that kind of tilted and you had to kind of have a mortgage to pay for it. Now you can buy this stuff at Best Buy for $50 a camera with a battery that it's all remote and wireless. There's not even any wiring. So I'm repeatedly encouraging condos to obviously talk to management, talk to legal counsel, because there are a few vagaries on where you should place them. But all things being equal, the Superior Court has ruled that there is a very low expectation of exterior common element of privacy in exterior common element areas. And there's a moderate level of privacy in hallways, but still you don't have a right to privacy absolute in a hallway. So the courts are saying that we're allowed to do this. We have to be careful where we calibrate them. But the whole issue of debate and dispute and compliance and all that conflict is eroded when we have the material that we need in the tools. And security, 10 out of 10.
Mhm.
I also agree. I think cameras would make our jobs easier as well, but with security comes a lot of other questions too. So who monitors those cameras, right? Because managers manage, but watching 24/7 hours of footage isn't typically how our day is made up, right? So
yeah, the general rule is you look at it on complaint. It's not accessible by the directors. I've had some directors, this is their alternative to Friday night TV. It shouldn't be. I generally think the rule is that on a complaint basis, the manager accesses it.
And that complaint should include at least a timeline, right? Like, oh, my bike was in there Friday and now it's not there Monday. Like that's 72 hours worth of footage, right? So
understood. Yeah, for sure.
I think we have to definitely, yeah, I agree. Security cameras make all of our jobs easier, right? And defining a complaint, right? I think is also like whose dog pooped there. Does that define a complaint? I mean, I think that we open a whole nother can of worms, right? So
absolutely.
But privacy is one of the things we want to talk about, right? Because questions we did get were, how do we address owners' concerns about privacy? And, what do we do? So Rob, do you want to take that one?
Yeah, privacy is kind of a word that I think is often a shield or you hear the word often in my experience for someone who doesn't want to do something, to be perfectly blunt. That's a privacy issue. So therefore we are off-ramped, we're excused from having to do anything because it's, quote, the privacy issue. Well, there isn't an express provision of privacy in the Condominium Act. The Condominium Act says there are 3 documents which are excused from production: the unit owner file to anyone else, insurance investigations, well, it's 4 actually, the employment file for a superintendent, and then a privilege and confidential information from counsel. They're kind of commingled. There's really 3, but you get the idea. Everything else is fair game for a unit owner to know. So if we're going to use privacy as a shield not to do something, we're going to find that the privacy entitlements in the Condominium Act are pretty thin. The courts have repeatedly said, and as Natalia will also echo by her experience at the CAT, Condos operate as a quote open book, and everyone gets to see the play. There's no secret. There really should be no secrets. So privacy is something that is largely eroded in a condominium setting to allow for the collaborative, transparent governance model that the Condominium Act creates. A lot of people will quote PIPEDA, Personal Information and Protection of Electronic Documents Act. It's a federal piece of legislation, not applicable to the condominium setting. Might be one day, we'll see. But people will Google and say, well, PIPEDA applies. It actually doesn't. The courts have said that on more than one occasion. So privacy is something that we have to really monitor expectations in the condominium setting.
What happens? Oh, sorry. And Evan, what happens when we have a police request?
Yeah, police requests are interesting. It's going to depend often on the circumstances, but we generally are not turning over documentation immediately to police without warrants. We are looking for police to provide reasonable grounds and produce documentation that compels the corporation to actually provide that surveillance. Your surveillance your surveillance system is not meant necessarily to aid police in their investigations. Your as we kind of just touched on earlier there, it's to assist the corporation resolving complaint-based matters. And so while there may be information contained in your videos or still footages that will be useful to the police investigation, the police know how to go out and get a warrant for those productions. And that's really what should be happening. We get calls very regularly. I'm sure Rob and Natalia have had it, where it's a panicked somebody behind the security desk saying the police are over my shoulder and they want this video. And we have to walk them through the process of you can go out, you can come back tomorrow with your warrant, and we'll turn it over. We'll maintain it. We're not going to destroy it or anything like that. But there are proper processes to follow in those circumstances, and it's important that they are followed. And sorry, just also I wanted to pick up on the privacy portion as well too. Rob kind of hinted at it that in the condominium context there's this lower level, and that's really something that owners have to understand. You're living in a shared community. This isn't a subdivision. You're sharing utilities, or you're sharing hallways or amenities with people, and that's really a vital part of the condominium framework, is this shared accommodation and shared living. And so there is some level of disclosure of information, of personal information, that is required in these cases. And it's always shocking to me when we get questions from boards saying, oh, do we really have to give the unit owner's name and their address for service to this person that's requesting it? And that is one of the fundamental things that owners are entitled to. It's a core record that any owner in your corporation can request the name and the address for service of all of the unit owners. And it's important for many reasons, but the idea that information is somehow so private, that boards are so concerned about sharing it because some owner has decided that they don't want that shared. We have confirmed again and again, the corporation has obligations to produce those documents, and it's part of the sacrifice that people choose to make when they choose to live in a condominium community. That shared living experience includes the sharing of certain information that you may consider private.
Very good point. Natalia, do you have any thoughts you want to add to that?
Yeah, just to sort of build off of what Rob said, is that, and what Evan said, is that from like baseline, you should assume that owners are entitled to all information of a condominium corporation, and there are only those very limited exceptions. And I do get oftentimes boards and managers saying, well, I don't understand why this owner wants this document. I recently had a CAT case where an owner requested all the plumbing inspection reports for every unit for the duration of the year. Why does he want these records? Who knows why he wants them? Nobody knows, but he wants them. And ultimately it was found that he was entitled to them, just subject to only redacting the unit numbers and names of all the other units. And I get the question, but why does this owner want them? And the response to that is, it doesn't matter. It doesn't matter why they want them. They might just want to have some light reading before bed. It doesn't matter. They are just entitled to those records. And that, again, as Evan mentioned, is just how condominiums work. It's shared information, shared spaces.
Yeah, if we ever thought there was a privacy right in condo, look at Section 19 of the Act. Section 19 allows a condo to make entry into a unit upon reasonable notice. It doesn't even say written notice. It says reasonable notice. Written's probably the way we should do it. So, like, think about it. If the police want to go into your unit, they need either exigent circumstances, a trail of blood, and someone screaming, and then they can kick down the door, or they need a warrant. That's really the two ways a police officer, or your consent. That's really the three ways a police officer makes entry into your home. And I think I agree with that. But in a condominium setting, oh no, wait for it. Section 19, Casey can write a note to that unit owner. We need to be there. Generally, the case law is about 48 hours. And we need to go in to check the plumbing, the smoke detector, and anything else we think that might be a common element that intersects with your unit. Think of that. Like, there is so few areas of law that give that kind of power to an incorporated entity over someone's home. So privacy, yes, of course we can't give unit files to other unit owners. That's a no-go. Privilege and confidential documentation, provided we haven't waived the privilege, and Natalia might tell us a little about that because the case law is getting pretty scary on that stuff. But otherwise, it's really an open book, and the condo operates with really X-ray vision, as they should, because we shouldn't have surprises.
Yeah, and to that point too, there was a lot of, I think, early on in the CAT litigation trying to really restrict what was a record or what constitutes a record. And I myself got caught up in some of that. And I think most of the legal profession has kind of thrown up their hands and come to the realization that almost anything in the corporation document-wise is a record. And to Natalia's point, we see it so often. Boards are so concerned. Why does this person want it? What are they going to do with this? Or we think they're going to do X with it, and we don't want to give it to them because we want to avoid that result, which we totally understand and appreciate. But the problem is that the CAT has said, listen, on a hypothetical, you can't deny a record on that basis, right? You've got to let it go out. And then if the unit owner does something, your remedy is then going to that unit owner and resolving it there. It's not denying the record on some speculative basis that we think they're going to be using it for some improper purpose. And it's really hard for a lot of boards to understand that, because some of this stuff, and the people in your community where you're going, if they get their hands on this, they're going to do X, or they're going to use it in this way. And it's something we really want to avoid. But again, this is one of those things where I think talking to legal early on and just getting that knowledge of understanding that while, if you start refusing the records request, we're going to be going down into a CAT case, and then you're going to call Natalia when you're in phase 3, and we're just left fighting an expensive CAT case. Whereas, it might be a quick 30-minute call where we say, give them the record and let's deal with it if something arises. And it's going to save you a lot of money in the long haul. That's a really good example of that, being able to involve legal early, saving a lot of money in the long run.
And that was something we talked about in our initial meeting as well, is how does the board keep legal costs lower? And your answer to that, I believe it was Natalia, was sometimes simplest solutions are best. Disclose and turn over records, right? Just like I think we can have a takeaway. We've talked about that. Another kind of tangent off of privacy and security is a question we got is, are trail cams allowed to monitor the common elements? So Rob, you want to take that one?
No.
Sorry, Rob.
Sorry. So unit owner has a trail cam and they place on common element. I've seen this before. I've worked on a case where this was real. I would, there's so much room for abuse there. I think that if a condo is aware that there's cameras being placed by unit owners in areas that are not in their exclusive use area, i.e. their patio, the condo should be taking all the steps to have those removed. Trail cams can be used for inappropriate surveillance, which I've seen, and had to participate in litigation. So I would certainly take those down. We also, Casey, do you want me to touch briefly on the duty to investigate, maybe ask Natalia or Evan duty to meet? Do we want to touch about, I think we kind of just jumped over that pretty quick.
Yeah, I think we can definitely do that next for
You
sure.
got some time? Okay.
Yeah.
So I'll jump on there's kind of two developing ideas that are coming through the case law. So these are not duties that are demanded in the Condominium Act or the regulations right now. This is stuff that's coming through the Superior Court, but largely through the Condominium Authority Tribunal, or we call it the CAT. I'll speak about the first one, and then I'll hand it over to Natalia, and then we'll get Evan's thoughts on both of them as we wrap. But the first is the duty to meet. There is no duty for a condo board to meet with an owner in Ontario. It's not in the legislation. It's nowhere to be found. It doesn't exist. There is a continuing and growing number of cases where the CAT says, you know, when the unit owner asked to meet with the board about their Section 98 approval for the hot tub or the patio expansion, and all you did was say no, and they asked you again, or they asked you about an enforcement issue regarding their pet, and the board said flat no, or what have you. You see what the consistency here is. The board saying repeatedly no to a unit owner's request doesn't appear reasonable. Bluntly put, doesn't seem cool. So is there an overt flashing, blinking duty to meet under the Condo Act? No. Is there anything in the case law that says thou shalt do this? No. But if you deny, or if we are not actively accepting a unit owner's request to meet, we're probably getting the condo into some hot water. So the duty to meet is a growing, I think, jurisprudential, can't pronounce that one tonight. The case law is saying we better do this. And I agree with them. You know, you have a 15-minute conversation with the owner, you explain the position. A lot of boards might be very skeptical of that. We don't want to meet with Jane Doe, John Smith. We don't like them. We never got along with them. They might have been previous on the board. There was some confrontation, bad blood, maybe some behaviors that have not been forgotten. We've all been there. I really think that this is in line with the consumer protection orientation of legislation. So duty to meet, highly recommend it. I'll turn over to you, Natalia, for duty to investigate.
Yeah, and that goes back sort of to our earlier conversations about simple solutions. And oftentimes just agreeing to meet with an owner either could resolve the situation early before a dispute even evolves, or if not, be not a bad way to say it, but if the matter were to proceed and dispute proceeds to court or the tribunal, optically, a judge will view it favorably that the corporation actually took the time to meet with this owner, to actually hear this owner out. Even if the corporation, although the board shouldn't go into the meeting saying, we know the answer already without hearing out the owner, even if the answer is still no at the end of that meeting, optically, a judge will, or adjudicator at the CAT will look favorably at the corporation's reasonable attempts to try to resolve the dispute without it escalating all the way to a litigious adversarial stage. So that would be something that even goes towards, say, a cost award. If the corporation is ultimately successful in defending an application or a claim or an action that a unit owner has commenced, and that those reasonable steps are shown, that really does work wonders for how the corporation and the board of directors is viewed in the long term. But again, taking that a few steps back, if that one meeting could just resolve things altogether, legal may never get involved, the expenses may never get incurred, and the aggravation of having to litigate something will never have to happen.
Evan,
And
you want to put
I think it's, you know, the thing that like I always stress to my clients whenever, you know, whether it's a compliance issue, whether it's a requisition meeting stuff, the word that's important for boards to remember is reasonable. Okay, you as a board member are expected under Section 34 to act prudently as a reasonable board member would in those circumstances. And so always coming back to, is what I'm doing reasonable? And again, always taking off those personal hats and putting on the board member hats and acting in the best interest of the corporation is going to really assist in this. You know, there's so many times where we get on calls or meetings with our client and we hear, okay, well, I want to do this. And we can look at the act and say, yep, you're technically allowed to do this. The act permits this. but then we look at the broader circumstances and say, is this reasonable? Is this really in the best interest of the corporation? Are you going to be creating more trouble than it's worth by taking this course of action? And what are you really getting out of it? And having those discussions is a really important thing to do. And touching on the duty to meet, in 2024, it is so easy to meet. You can do these virtual meetings. It's so easy, and not just for meetings with owners, but quickly meeting with boards for boards to make decisions. Your bylaws probably say you've got to give X number of hours or days of notice, but if you all get together and say, hey, we're going to just quickly meet on this, and we all waive the requirement for 3 days notice, you can have a board meeting just like that. And it's a really productive thing. A lot of the times, we would always encourage you to set timeframes on this. Again, we appreciate that board members are volunteers and this is not your full-time job and things like that, but meeting is really, really important. And it's so easy to do. Even if you've got to just hop on to do one specific issue for 10 minutes and get off, meet. It is really important to do that.
Yeah, and then the second idea, and we'll go around the table as well on it. The duty to investigate is the second evolution that we're seeing in the jurisprudence. So 20 years ago, if a unit owner complained about another owner on their noise, there really wasn't any overt investigate duty for a board to kind of figure out who's saying what and get written complaints and then maybe do a site visit and all those sorts of things, almost like a quasi police power or bylaw enforcement in a municipality. As Natalia will tell us, at the CAT now, the CAT has a lot more scrutiny on who's the complainant, what did they say, what did the board do, who did they talk to, who did they meet, what did they review in terms of footage, did they talk to counsel, did they talk to an engineer, what did they say? So is it like a duty to investigate that would be akin to a police power? No, far short, but some investigation is required, that the board doesn't look like they're just picking the party that talks to them first. And that's a very human default. I think it's kind of bias of first instance. You kind of believe the first person who tells you something, because then anyway, I'll spare you that detail. So you can't just listen to the first person who's talked to you. Okay, what does the other person have to say? And then the duty to meet also has a role to play in there as well. So this cultivating idea at the CAT of a duty to investigate might also avoid later problems and also your legal bills and conflict erupting. You might actually do a proper investigation. There's nothing to look at here. You know what? We checked the footage, we talked to everybody, nothing to do here, and rather than get yourself in costly litigation. But I'll turn it over to Natalia.
Exactly. I think both of those go hand in hand generally in what the courts or the CAT would look at as reasonable conduct at the corporation level. And CAT and the courts love to use the term reasonable. It's everywhere. It's not defined anywhere, but it's fact specific as to what's considered reasonable. And to Rob's point, those simple steps could avoid a long, costly, aggravating battle in the long term.
Natalia, you did get a question of when is it the role of the board to meet someone when there's a complaint, and when is it the manager's role?
I think that's also a sort of fact-specific case. Typically, as Evan mentioned earlier on, the manager is that liaison figure, not only between, let's say, legal counsel and the board, but also between the owners. It's usually the first point of contact for owners to send in complaints to the manager, send in questions to the manager. And the manager can meet with the complainant on an initial basis and to see what's going on and perhaps schedule a meeting with the board if it's not being able to resolve thereafter. But if an owner specifically requests, hey, listen, I've been having this issue in my unit for such and such time, I want to meet with the board, I think that the board should accommodate that type of meeting with the particular unit owner.
Definitely. Evan?
Yeah, on the duty to investigate, I think it's really important too that, as Rob said, you don't want, it's human instinct to, chat with the first person and take that for their word and go from there. But you really want to avoid situations that I'm sure we've all come across where, it says, well, the owner next door or the person that's being complained about says, well, you never talked to me to get my side of the story. And I would have told you this, and this is how it started. And here's some extra background that, really colors it. And so it is really important to do those investigations and, you know, be somewhat creative. You know, if it's a noise complaint about from unit owner 1 about unit 2 next door, ask unit 3, ask unit 4, have you guys heard any complaints? What's happening? You don't have to always limit it to just the parties that are at issue. It may be that this is a broader issue that other people are observing, but no one is necessarily coming to the corporation about it. And that's something too for the board to always be reminding owners, is that condominium corporations, as you've heard tonight, are complaint-based compliance organizations. Okay, you know, as much as the board is probably on site and the manager may be on site from time to time and may observe specific infractions of rules and things like that, largely condominium enforcement comes from owners making situations, making the board aware of situations existing. And so it's really important that boards continue to remind owners that you can't do anything to solve their problems unless they tell you about them. And that's something that comes up, you know, at AGMs, we see it all the time. Well, for the last 4 months, this has been happening. Have you written to us? No. Oh, okay. Well, thanks. We've got it now, and we'll start looking into this. So something to keep in mind there as well.
I was reading a book,
Go ahead, Rob.
just to wrap up, and then I'll stop talking. I was reading a book a couple of days ago. It was talking about the how juries make decisions. Juries, as we know, are not lawyers. They're generally not, a few exceptions. Juries are often tasked with making these monumental legal decisions without the legal training that necessarily goes along with that. Juries generally, they find, particularly in the United States, they make the decision on who they trust. The behavior that they see in the witnesses and the lawyers echoes their decision-making as to, quote, who they trust. CAT members are highly educated individuals, but they're not lawyers generally. They're often other careers, and they come to the CAT as kind of something else. They're very acquitted. I'm not trying to diminish the role of the CAT members, but when you look at their decisions, it's the same kind of equation. Who do they trust? Who do they think's been more reasonable? Who thinks been more appropriate? Who is showing a more deliberate, clear path of behavior? And the decision sometimes seems to follow those facts. So as board members, don't be capricious. Don't be quick to judge. Don't ignore something. Take the time to make the deliberative decision. Get legal counsel. All those things. So you build that trust in the metaphorical jury, which in this instance is the CAT member, who then has a decision that follows often, again, who they trust.
Excellent. That's an excellent tip for sure. We have spent a lot of time on security and meetings and conflict a little bit, because those CAT cases have definitely, we've seen an uptick in where CAT cases are going in the condominium landscape. Another type of meeting we've seen an uptake in is requisition meetings. So do you guys want to talk about kind of how a board deals with that? You know, suddenly you're faced with a requisition. So Natalia, you want to start this one off?
Sure. Probably good to start this one off since I just had 4 this month, or at least in October. Yeah, so I have seen a large increase in requisition meetings, and they're not the typical requisition meetings as to voting on a rule that was proposed or voting to remove the board. It's requisition meetings to have discussions about particular topics that owners want to air their grievances on, express their concerns on, etc. And so in these meetings, there's no voting happening. It's just talking about the specific line items that the requisitionists want to talk about. Oftentimes, these are certain things that we end up not being able to talk about because they're unit specific, or they involve litigation, or they fall under one of those very few exceptions under the Condo Act. However, when I meet with boards prior to these requisition meetings, how to prepare for them is to go through the items that these requisitionists want to discuss and want their voices heard on, and have actual responses provided. Typically what the requisitions want to hear and who they want to hear from are the board members. Because I've had requisition meetings where I meet with the board prior to, and then the board instructs me to respond to every single question. We prep it. I'm just there as sort of a shield to the board, but oftentimes the owners want these answers to come directly from the board members, because they're the ones who the owners have elected. They're the ones who make ultimately the decisions on behalf of the corporation. So just preparing for those meetings is to actually have responses to the grievances, concerns, the issues that the requisitionists want to address at that meeting and be able to respond to any questions that may be raised about those particular items. Of course, requisition meetings are never fun, especially for boards, and even more so oftentimes for the managers. But owners do have a right to requisition these meetings and to air their grievances out. And oftentimes these requisition meetings, at least the last 4 that I've had in October, they ended up everyone left copacetic, happy. They got to have their voices heard. They got to express their concerns, and they want to move forward in a positive light. It's not always such a negative thing. Sometimes it could lead to the community coming back together once they're able to just address their concerns, have their voices heard, and have that meeting that they so desperately wanted in the first place.
Evan, you want to take over?
Yeah, I haven't had the same experience with requisition meetings just for discussion purposes. Most of mine come for board removal and things like that. But to the extent that those meetings are taking place, I think that also kind of signals an opportunity for boards. It sounds like maybe then owners feel like the boards haven't fully communicated or explained certain decisions that are being made. And one of the trends that we tend to see are these informal meetings of owners. We are all aware of our annual general meeting. It takes 35 days. You've got to send out these formal notices and things like that. But what we're seeing emerge more and more regularly when corporations are making certain changes or want to get a sense of where the community stands on these sorts of things. As of course, you can use like a Survey Monkey poll and send it to owners and see what responses come back in. But you can also give we call them town hall meetings. It's not a formal meeting of the corporation. You don't have to send out the notice. It's a simple board says, hey, everybody, we want to meet in the library for about an hour. We've got an agenda. We just want to talk about these 3 things, get a feel for the community about how we feel about this. They're still minuted. That's really important. Those still need to be minuted. Maybe you're not hiring a professional minute taker, but there should be minutes of that meeting. Which become a record of the corporation. It's one way to really ensure that, or possibly avoid those scenarios where you're getting this uncomfortable requisition and you're nervous about what are they trying to accomplish and things like that. If you can get ahead of it by communicating, usually first in writing about what the changes are and things like that, and then offering a town hall meeting, it's something that's really useful. But yeah, to Natalia's point, requisition meetings are always uncomfortable at first instance. Obviously, there's tension that's built up there, whether it's to discuss certain line items or things like that. Most of mine that I've dealt with are for removing directors, and that's always a very sensitive topic. The boards are working together. You're a team of 3, 5, however many you are, and to see one or all of you targeted is quite shocking. But again, it's always coming back to that. How can we reasonably respond to this? So it's calling the meeting in accordance with the act. It may even include reaching out to the requisitionist and saying, can we resolve this in another way? But they're of course entitled to have their meeting. One of the things I see often with requisition meetings is that they're the requisitionists aren't quite thinking about timing, and so they're requisitioning a meeting 10 days before the AGM, and they won't consent to delaying it to the AGM for whatever reason. But again, we have to look for reasonable solutions there, and always kind of responding with a reasoned approach, notwithstanding that some of this stuff is very tense and can be seen as very personal attacks on board members. It's always important to take that board hat, put it on, and go to work in that board capacity.
Rob, any way to finish?
Yeah, my experience, most important thing is hold the meeting. Have it. I can't count how many times I've got an email from a manager, board member, fellow lawyer, or what have you. Hey, how do we get out of this? Can we discount some of these signatures? This signature might look like this is printed. I don't know. These don't seem to correlate. This person might be in arrears. We can't tell for sure. Hold the meeting. That for me is the perennial advice. They're uncomfortable, sure. I was at one recently that went on for 3 hours. Was that, my most enjoyable 3-hour evening of a weekday? No, probably not. But It's going to spare us hopefully another requisition meeting and then to consider the removal of the board. And then, secondly, for what it's worth, my humble legal opinion is one of the most important human motivators is to be heard. Like if you're not heard, you're never happy, ever. You don't walk away and great, that was wonderful. I put a requisition and they won't listen to me. I personally think that a lot of requisitions I go to, it's the metaphor of a train coming down the tracks. Don't get in front of it. Let the train go through. That's the will of the owners to express it. Don't get in front of it. Let it happen. And sometimes if we're open-minded, they might actually say something that's of value. So most important thing, hold the meeting.
100%. All good points for sure. We're going to move on. We've got about 30 minutes left and we're doing a great job of answering questions. And if we haven't gotten to it, we are getting to it, I promise. So stick with us here. Let's talk about the economy and how the trend we're seeing in condos and the spike in lien enforcements, power of sales, and legal costs for non-compliance. So how can we, what can we do as far as all of that stuff goes? Evan, do you want to start with this one?
Sure. Yeah, lien enforcement is certainly on the rise now. Interest rates are coming down, and that's certainly helping certain people with variable rate lending. But we still are seeing a tight economy, and we are seeing lien enforcement. The first and most important thing is that time matters with liens. You do not want to miss that period where you can perfect your lien. Okay, so when you're getting those monthly reports and seeing that somebody's in arrears, again, there's no requirement in the act to give them notice of the arrears short of the notice of lien that goes out 10 days before you register. But it's what I would say common practice at this point after a missed payment to see a reminder go out to say you've missed a payment. It's maintaining that communication level and things like that. You're going to hear the sob stories, and they're real, and they do pull at your heartstrings. There are people that are in tough times. Don't let that affect your judgment. You've got an obligation as a board member to secure the payment of common expenses. The lien is the easiest, most cost-effective way for the corporation to do that. Get the lien on, perfect your security, and then you can kind of extend the olive branch and find out if there's a payment arrangement and things like that that may need to be considered. But you don't want to jeopardize your security. That's a really powerful remedy for corporations. And it's not one that the courts like to see that the corporation slept on. You're not going to be able to go back and try to secure amounts that aren't secured by the lien. So it's really important to get those liens on in time. Once the lien is on, your normal enforcement proceedings go on. But again, this goes back to our earlier discussions of communicating with owners, meeting with owners, trying to resolve this. You don't want to engage, especially when we're talking about residential units. Going through a power of sale process is a very emotional thing. For board members, these are your neighbors. For the people that you're enforcing against, this is their home. And so to the extent that you can, avoiding those power of sale proceedings is always welcome. Depending on who the owner is and what their financial situation is, there may be a mortgage on title. And by putting that lien on title, you may get your arrears paid from the mortgagee. Some mortgagees aren't doing anything now until they see a power of sale notice, which I don't know why they're waiting. It's just increasing the fees, but that's what they're doing. And maybe it's to really give the owner an opportunity to redeem that property in advance. So it's important to get the security on, perfect it in time, and then we can deal with it. The power sale process takes time, but it's one that we try to avoid. I just had one the other day where we were working through it, and it's a very emotional process, especially when estates are involved and then there's deaths in the family, and that's part of the reason, and there's ill parents. There's so many reasons, and they're all very emotional, and it's really important though that the security goes on and is perfected.
100%. Hey, Rob, do liens have an expiry date, or do you need to review them regularly? What should
Liens have to be registered within 90 days of the debt. I don't think that's the question, but I'll just give the background. So liens have to be registered within 90 days of the debt arising. So that generally, if it's a monthly common element fee, you've got your 3 months from the date the debt arises. But the question is more nuanced once you get the lien on. So the lien's registered. What's its timeline? I haven't read the perfect case that gives a perfect answer, but my interpretation of the Real Property Limitation Act, if I quoted it correctly, is 10 years. It's not the 2-year limitation under the General Limitations Act. It's the 10 under the Condominium Act. But for me, those limitations are a mug's game. My advice to condos are there's some time period that you wait. So you get the lien on, and no one pays you because no one's compelled to pay you if you have a lien on. It doesn't mean there's something to check that automatically falls in your lap. Generally, that's the experience, but people don't have to pay. My experience is that after probably about 6 months, that's the time to give a notice of power of sale. And that's you're using a different part of the legislation. Now you're using the Mortgages Act. So you diarize the 6 months, then you proceed, and you can ultimately notify you're going to sell their unit, and then sell their unit 45 days thereafter after a redemption period. So yes, we can wait the 10 years. If we want to take a more conservative interpretation, use the 2 years on the Limitations Act, we certainly can. But my general advice is wait 6 months. And if you're still unpaid at that point, probably the fix is in what's going on. We know what this behavior is going to be, and then proceed with the power of sale at the 6-month mark.
Perfect. Natalia,
Yes.
we talk about legal costs, and when we're trying to get compliance or have a chargeback, when can that owner be charged back those legal costs?
So the hottest topic in condo law since the Amlani decision, but it really depends. First and foremost, the main thing to look at is your corporation's governing documents, whether or not you actually have the authority and power to charge back. Most declarations and bylaws, they do have some form of indemnification provision, but it depends how strong that indemnification provision is. Newer corporations, their indemnification provision, they have multiple throughout their bylaws, rules, and importantly, the declaration that actually specify that for compliance-related issues, solicitor fees are something that fall under what a unit owner is responsible for in these compliance-related matters. So that's the first thing to look at in terms of, can I actually charge back these costs? And now the second thing, and going back to, again, the term reasonable, is it reasonable to charge back these costs? So we've had corporations in the past contact us after a first incident. The unit owner has never been put on notice that their smoke is wafting into another unit, or they're causing noise, whatever the issue may be. And they ask us to draft a legal letter and charge back those legal fees to that unit owner. So completely unreasonable. The unit owner needs to be put on notice first by the condominium corporation, generally through management, about the issue, and provide an opportunity to comply with what is being demanded. Oftentimes we see 1 to 2 letters, potentially a meeting, as we talked about the duty to meet earlier, until it goes to legal. And what I strongly recommend always to our clients is that at that final enforcement letter, make it clear and spell it out to the unit owner that if this continues, this will be referred to legal counsel, and the costs, which will probably be around this sort of 500, 600, whatever it may be, ballpark figure, those will be charged back to your unit, and they will be treated as common expenses payable for your unit. So the owner is on notice that that's the next step that's going to happen in the process. And they're not surprised when they do get that legal letter with that corresponding chargeback. And there's been multiple cases at the tribunal that specified, oh, we're going to actually order the cost pre this CAT application, so those costs of the enforcement letters, back to the unit owner by way of this order, because the condo court put them on notice. If you do not comply, this is where we're going, and this is the next step, and these are the costs that are going to be associated with that. So that's something to keep in mind, to put that in that final compliance letter. I go so far as to say, you typically, if we have to send out 1 or 2 legal letters or 3 legal letters, whatever it may be, at that final legal letter, I also put in my letter, if this does not stop, we will be commencing a CAT application or a court application against you. These are the costs that typically we see in these sorts of application, and we will be seeking those costs against you. The transparency of providing that notice, and that the owner is not surprised when they do get that chargeback either through the first legal letter or through the court application or CAT application. They know that this is going to happen. They're aware these are the next steps and these are the cost implications that are going to go against you. But then ultimately, when it comes to CAT or the court, the judge or the adjudicator has a discretion as to what to actually award in terms of costs back to a corporation if they are successful. In CAT, the trend is almost nothing typically, which is unfortunate. They typically just give back the $200 filing fee, oftentimes the pre-CAT costs, they call it, so the chargebacks for enforcement letters, and then a nominal amount, except in egregious situations, for the cost of the actual application itself. And then the court ultimately has discretion to award costs back that way as well. But I just saw a case come down, I think it was earlier this summer, and it was Davies. And in that case, the judge awarded no costs back because under section 135(5) of the Condo Act, if you bring a court application under section 134 and you get even $1 back in costs, technically the corporation could then charge back and lien for the entirety of the legal fees spent. And in that case, they said, well, we're not awarding anything because we know that the condo could do that. It charge back and lien for all of the costs incurred, so we're not giving any cost award whatsoever. So once it goes up to that higher litigation stage, it is really discretionary on a judge. But for the earlier stages, the compliance letters, the letters from management, those are the things to consider, putting them on notice early. These are the fees that will happen if you do not comply with our initial letters.
Evan, did you want to include anything in there?
Yeah, we see this all the time. Boards are really concerned about, can we charge this back? Can we recover this? And most of the time, even if a board has ironclad indemnity wording that says, if the owner does X, you are entitled to be indemnified, and the owner has done X, we still have to caveat our opinion about whether or not you can actually or will be successful in recovering these fees. And it's a reminder to boards, and something we talked about a bit earlier, is that you are a corporation here, and there is kind of the cost of doing business, unfortunately. And so it is really important to be budgeting for these things. And, again, while there may be really clear situations where there's a good case for the corporation to recover all of its costs, we still can't guarantee that in Ontario following the Imlani decision. And so it's really important to understand that even if you have really strong indemnity provisions, and if you don't, or you're not sure, go check. And if talk to the board and make a decision about whether or not you want to upgrade or update your indemnity provisions, because that's something that we're seeing a lot of corporations get caught with. They want to charge back. Everybody thinks you can charge back, and then they have this really terrible indemnity provision that doesn't give them any entitlement to do so. So that's one of the first things you need to be doing there, is making sure you have that indemnity provision. But even if you do, boards have to accept that there's a certain risk with chargebacks, and there's no guarantee that if the owner doesn't pay it on demand, that we will be able to enforce it by way of lien, or enforce it successfully through court applications or through the CAT. And so boards have to be prepared. And we have a standard letter that we send out explaining all of this. But it's a really complex area of law, and it's something that boards have to be really cognizant about, and not be afraid to take enforcement action because they might not be able to charge back. That's the really important step too, is you still have a duty as a board to enforce your documents and to enforce these provisions. And just because you might have to eat some legal fees doesn't mean you shouldn't take enforcement action.
Rob, do you want to close this one off, and then we'll move on?
Yeah. We're addicted to chargebacks, bluntly put. Lawyers, managers, boards, the whole gambit of us. We're literally addicted to this. We don't want to do things unless we know we have an ironclad chargeback. We've got to break that pattern. Chargebacks are nice. Again, a wonderful present under the tree at Christmas, or a nice birthday present or a gift from a family member. Those are all wonderful things, and chargebacks kind of fall in that category. They're not guaranteed. We still have the duties to enforce. We still have the duties to follow the Condo Act. So while we should pursue chargebacks, we should never make the recovery or lack thereof of a chargeback be what determines the decision, ever. It's wonderful if you get it, but it shouldn't stop you from the business that has to be done. Just like Evan said, the cat has recently said, the cost of doing business sometimes is paying stuff on behalf of the condo. So I've seen a lot of boards. I understand why they're fiscally prudent, but you can be too fiscally prudent to the point where you're now being, the penny wise, pound foolish analogy. So chargebacks are great if we can get them. We could probably talk for hours about the hierarchy of chargebacks and how we get them. They're not a guarantee. Pursue them cautiously, but don't let them stop from the business at hand, which is governing the condo.
Awesome. And we're going to move on just because we are getting close to our time. We're going to talk a little bit about neighbors and whether those neighbors aren't directly within your community, right? They're neighbors who aren't part of the condominium corporation. And a couple of questions we got in this realm was, is a condo corporation legally obliged to alter grading, install drains, or otherwise mitigate risk of water runoff from the property onto a complaining neighbor's property? And I'm going to give you one more question that we can talk about as well, just so we don't have to interrupt it. But as well, if a neighboring property refuses to share the cost of replacing a shared boundary fence, is there any action that the board can take? So Natalia, you're up.
This sounds like an Evan question, so I'm going to turn it to Evan.
I'm going to call you.
Sure. Okay. I'm going to give you the most lawyerly answer to start. It depends on a lot of that stuff. The first question, there's probably two ways that this could come about. Site grading and things like that can come out of your subdivision or development agreements. The corporation may have an obligation to maintain certain grades or to maintain the property at certain points. To the extent the corporation has performed some sort of alteration that altered those grades that wasn't approved by the subdivision, yeah, you may have an obligation to restore that to prevent water flowing onto their property. To the extent that there hasn't been any changes, the other neighbor may still have a claim in nuisance against the corporation for permitting a substance to flow over the property. So it really depends on the specific circumstances. And this is one of those things where if you can't resolve it neighborly, getting legal involved early on can really help determine what are your obligations here. It's a really important one. We see it all the time where you've got salt water staining patio stones or something like that, and now we're spending all this extra money cleaning it because you're letting your pool water flow over here. So it's very common. The fence one is a really interesting one. It's one that I've dealt with personally with my own neighbors here, but it's one I've dealt with for corporations as well. And again, the answer depends on where you are. And I did just take a quick look at this. Waterloo has a fence cost sharing bylaw. Kitchener does not. Cambridge has a fence cost sharing bylaw. Toronto does not. So it really depends where you are. And I was dealing with one in Hamilton the other day. And I think there is a fence cost sharing bylaw in Hamilton, but it said that there's no fence cost sharing obligation if one of the parties is required by law to maintain the fence or to build the fence. And so the question became, well, does the obligation in the subdivision agreement, is that an obligation at law for you to now maintain this fence forever at your sole cost because of the way that the bylaw interacts with that? So it's really, really going to be dependent on where you are. Probably start with a Google search about fence cost sharing bylaw city of Waterloo. That's literally all I did today. And it says, yep, this is the bylaw. You'll go through there. If there is cost sharing provisions, it'll set out. You've got to give registered notice with 3 quotes and things like that. And you can chase them for provincial offenses and things like that. But I'll use my own personal experience because, of course, I deal with that a lot for work. I wanted to do that to my neighbors, my own personal neighbors here, because they were dragging their heels about getting this fence built and things like that. And thank goodness I'm married. And my wife said, you know, we have to live by them for the rest of our time here. It's not the nicest thing to do to your neighbor, to kind of force them into it. And the obligations in most fence cost sharing bylaws aren't obligations necessarily to rebuild the fence or build the fence that you want. It's generally sometimes the cost to build a basic fence, which is a 4-foot high chain link, which is not going to be terribly expensive versus your, artistic wood design fence and things like that. So neighborly solutions, reasonable solutions, find out what your obligations are always. And I feel like I've been talking for a while, so I'm going to stop.
No, I think that Evan, great points there. I think one of the things that I notice is that, me included, is that we kind of get narrow focused on our duties. I'm thinking right now, let's say a townhouse condo in southwestern Ontario, and the manager goes on a site walk on the property. I guarantee you that walk is just strictly within the boundaries of that condo. Human nature, right? Why aren't we walking around the street that rings around the condo, or knock on the door of the neighbors? Now, I'm not saying that we're trying to meet trouble halfway, but a lot of these things are, when they come to our doorstep, they're a complete surprise to us, and we're all oblivious to it. So I think condos should start to get exercise the muscle of, you're a part of a community, you have interrelationship with other members of the community, whether you like it or not. Water, dogs, noise, lighting, those are issues that largely govern us in condo, but they also affect us from the external elements of the condo as well. So I'm a big fan of try and understand what might come down the pipe. Walk around the neighborhood. You might not have to knock on anyone's door, or if you want to, I would encourage maybe consider that maybe once every couple of years. But walk around the neighborhood. What's going on? Is that fence falling over? Is that person have a fire pit in their backyard? Is the smoke coming over? We are really good at focusing on what's on the internal. I think it's time for us to start thinking what's on the external as well.
I think those are excellent points. Thank you guys so much, because it's very true. When those external ones hit us, we kind of go, oh heck, what the heck, right? And I think
surprise
it doesn't matter to us because it's not in that community space, but
That's right.
it really is, and we need to pay more attention.
Leave the bubble.
Yeah, exactly, 100%. So another question we got, and I think we'll sort of close it off on this one, is what is the government doing to regulate how many non-related people can live in a unit? And so, I mean, this obviously presents a bigger issue because we know that, condos don't necessarily meet the demographic these days. And so we do see, or housing is super expensive. So we do see, large numbers of people living in units. And so can we rely on the government to take charge of this problem for us? And Natalia, you want to start this one off?
So the very short answer, but I'll explain further, is no. The government isn't really doing anything to regulate this, but corporations can regulate this internally. So corporations can pass things like occupancy standard bylaws. They could also pass rules, depending on what the declaration says, about like boarding houses or rooming houses, how many occupants per unit, single family dwellings. So there's a lot of options for corporations internally, whether that's by way of bylaw, which of course is a bit more complicated because you do need that majority vote of owners for those types of bylaws to vote in favor of the bylaw. But there are rules that could be put in place, provided that they're not inconsistent with your declaration and your bylaw, to regulate the amount of occupants in these residential units, and to regulate what types of occupants in these units. I have a situation in Toronto right now where there's a bit of a dispute in terms of, is it okay for two roommates that are two students going to Ryerson University to live in the condo if the condo is a single family dwelling? So there are options for corporations in terms of regulating this internally, but in terms of the government doing anything to regulate this on a more wide scale, unfortunately, no, we're not seeing that happening as of yet, at least, and I don't anticipate it to be happening anytime soon.
Rob, you want to jump in on this one?
Yeah, I'm thinking back, 20 plus years ago. I know it's a surprise to everyone, but when I started practice, the really big concern, sorry, Caitlin, if that embarrassed you, The really big concern we had in the industry was the tyranny of the student, the horrible student who is going to, you know, these units are going to be taken over the students, and we're going to pass declaratory amendments to limit the number of students and units. And I literally I don't even want to count how many hours I spent working with the condos, declaratory amendments to cap the number of students in a unit. And I can't count how many enforcement files I've done where I'm using those declaratory amendments. I don't think one. You know, yes, we can pass these bylaws. Yes, we can go after certain users to stop them. I really think that the path is focus on those who are violating. It's like the broken window theory. I know he's now a rather discredited politician, but Rudolph Giuliani in New York said, I don't need more laws. I don't need more police. I don't need more resources. I don't need more ideas. Go after people who violate even the small stuff, and the big stuff will take care of itself. And I'm a big fan of condos saying, let's not pass declaratory amendments. Do a walkabout with the manager, document the violations, and then have letters to follow on that. And people will either vote with their feet. If they want to comply with your provisions, your declaration bylaws and rules, people will. And if not, we'll either have to enforce, or for sale signs will go up. So yes, I appreciate, you know, students and the use thereof and single family, and I get all that. But I'm a big fan of chase those who are the violators, and the condo will probably take care of itself in the end.
Excellent. Evan, anything to add to that?
Yeah, I think, you know, it's funny, I hadn't thought about it, but to Rob's point about, you know, this big influx of protecting against the students, I remember, you know, when I was drafting documents, there were pages in builder documents about protecting against students, and I articled in Waterloo region, so I know, you know, the big universities there, and so I appreciate the concern around Waterloo and Conestoga and Laurier. But, you know, it seems a very common thing. You know, in 2017 and 2018, we were all drafting rules like crazy, prohibiting cannabis and outlining smoking. And I'm seeing a big uptick now in these occupancy standard bylaws as we're seeing these sorts of things come through. And you know, and even the electronic voting bylaws as well that we all did at the start of the pandemic, which was somewhat necessitated by the pandemic. But I think it's key, as Rob said, not overreact in this case here. Go after those people that are violating. You know, even when the boards have problems and they try to implement these occupancy standards bylaws, I find more and more the owners show up and say, this is draconian. We don't want these sorts of things in here. You know, we're a community, and it comes off really heavy-handed to propose these things. So to the extent you can avoid it, don't get me wrong, it's a useful tool, and if it's needed in your community, you've got the support of your community, definitely get them through. But there are other ways to address this in your community, and it's probably a more community-oriented approach.
All excellent points. And I think we're going to end tonight because we're at 8 o'clock and I don't like to go over. All excellent points, as it is a community, right? And it's all about, you know, being open and transparent and talking to each other, right? Yes, put your board hat on, but you are a neighbor too, right? And you bought into the same community, so you must have some of the same values. And that's what's important to remember. The one topic we didn't get to that we wanted to talk about potentially just though was if there's conflict within the board, right? So as a board, you want to be a unit, right? You were elected by the people for the people, right? That, I mean, I know that's, you know, a catchphrase, but it is what it is. You were elected by the people for the people. You should all have differing opinions, right? Like that's why you're there. We want to have lots of insight into how this is, because you should be a reflection of the whole community. And so the one point that we made, and I'll give you guys all 2 seconds to kind of talk about it in a second, is that if you have conflict within the board, don't hold, you know, special meetings without a board member, right? I mean, don't hold private meetings. Invite everyone, be transparent. Evan, 1 point on conflict in the board and how you fix it.
Okay. Not how to fix it, but conflict in the board. We've seen it as of last night. You've seen how divisive, you know, people with opposing views can be. again, you are neighbors with these people. You share an investment with these people on the board. Be respectful, be courteous. You can politely disagree with people, and it's okay. And it's healthy for your community.
Awesome. Rob?
Hold meetings on Zoom and record them. People act a lot better when they know the camera's on and the recording light's on.
100%. Natalia?
Well, I agree with both, Rob, and because you would also have the mute button available on Zoom meetings, which is a fantastic feature. But just be transparent, just be open with your board members and have those meetings to discuss those difficult topics, but make sure you do so with the thought at the back of your head that this is also an owner, presumably. This is my neighbor. This is a human being. So having that bit of respect and courtesy goes a long way to resolving that dispute in the long run.
All excellent points. I think Evan touched on it. We saw last night, in the US election, some division, obviously. But again, they are all people of the United States. You are all people of your condo, and kindness does go a long way, right? I mean, you can all have your own opinion, but kindness does go a long way. Thank you to everyone for joining us. We're happy to end the year on our legal session, always well attended, and we've gotten lots of questions. Thank you to our panelists for attending. On a quick closeout, Evan wanted to hang out with Winnie the Pooh, Natalia wanted to hang out with the Pink Panther, and Rob was with Spider-Man. So for those of you who guessed, I'm not sure how many of you got them all, but congratulations if you did. We are thinking our next session might be on another heavy topic about fire enforcement and fire safety and all of those things within condominiums and the regulations and how they apply to condominiums, a big hot topic. We tried to get it in today, but we knew that it would just be too large of a topic for us to touch on. So if you have any other topics that you would like to see us do, please reach out to Kathy and she will definitely get those to us, or to your PM. They could definitely bring those to us as well. We are holding 4 of these a year. We do record them and upload them to our YouTube channel. Well, not we, Caitlin, but definitely you will see it. And thank you again to everyone who attended. Thank you again to our panelists for your time. We really appreciate it. And I hope everyone has a wonderful evening. Take care.
Great, thanks.
Bye.
Take care, everyone.